Hey viewers, Peter here. Welcome. University of Nairobi School of Law, Kisumu Campus, Social Foundations and Perspective of Law. Critical Legal Studies present to us various scenarios when it comes to the legal systems in the world. The other time we looked at the legal systems and the history of law in Somalia, legal systems and history of law in Ethiopia, as well as in South Africa. This time round, I want to believe that it is the appropriate time to look at the cradle of humanity, the Republic of Kenya. Well, all the same, we have to go back a little bit in time to look at the history, how it all started. Well, Kenya became officially and declared part and parcel of the British East Africa Protectorate in 1897. 2 years before that time or prior, the British authority, that is the colonial power, had entered into an agreement, quid pro quo agreement, with the Sultan of Zanzibar. The strip of the coastal region in the Eastern Africa was under the caliphate of the Sultan of Zanzibar. Well, quid pro quo meant that the British colonial power had to give in to some of the demands of the other party, whereas the Sultan of Zanzibar had as well to give in some of his power over the caliphate. Well, the agreement was to access the Indian Ocean or the maritime accessibility by the British colonials because of the transportation of the goods from the colony, which was Uganda, to Britain, which was quite much in need. Well, in this case, again, we find that Kenya happened to be colonized accidentally because it was providing railway linking Mombasa and Uganda. And in this case, the transportation through Lake Victoria, Port Florence to Mombasa would enable the transit of goods from Uganda to Great Britain at that time. Well, as early as that time, what was in this arrangement between the Sultan of Zanzibar and the British Royal Authority was give us the access to Indian Ocean and will protect your rights within the empire known as the British East African Protectorate. Well, the agreement was done and the Sultan accepted the offer. The British accepted to take care and protect the Muslim minorities and the existence of Qadhi's court system, which was already in practice for a long time before the arrival of the British colonial power. Well, how about Kenya? Well, there was nothing substantive because Kenya became part and parcel of the British East African Protectorate. So that includes Tanganyika, Uganda, and Kenya. And in this case, not so much had been developed when it comes to the use of studies and education in terms of law. Well, what was existing at that time by the British was the University of Dar es Salaam. Well, later on, the University College of Makerere in Uganda. These were the high learning institutions within the empire or the protectorate, and in that case, most of the learned Africans by that time had to go either to Tanzania, Tanganyika, that is Dar es Salaam, or Uganda, that is Makerere. Well, that is historical legacy, and the teaching of law was done by the same British colonials. And in that case, some were from South Africa, some came from Britain directly, some came from India, as well some came from Egypt. But this gives us a picture of how law was taught to the Africans within those colonies by that time. Well, all the same, with pass of time, we know that Tanganyika was under the German colonial power until the outbreak of the First World War, in which Germany lost the war and surrendered most of her empires, her colonies in Africa to the British or to Belgium and France. Well, having this kind of complicated historical background of the law and its making, we go directly to the Lancaster House in London, where the first constitution that brought independence to Kenya was discussed, debated, and drafted by the Legislative Council, which had also some small number of the African representation, the Sultan, as well as the Royal Authority. The agreement was, the arrangement, that the strip of the coastal part must be part and parcel of the Kenyan territory, with the condition, though, that the Cadiz court system must be accommodated within the constitution and protected by the constitution. Well, at the independence, well, it was done, and the constitutional agreement and promises were protected and safeguarded in 1963. Well, afterwards, Kenya had to think about the African legal system, how to bring African customary law into the legal system. This wasn't an easy task. Well, the government and the administration by then established an ad hoc commission to carry out research into the African customary law and come up with a report on how to legislate on African marriages and divorces according to those customs. Well, this makes me recall one revered Justice Eugene Cochran, a Briton and a Jerusalem-born professional who had particular interest in developing African law and African legal system. He had interest in African customary law. Well, Professor and Justice Cochran left a lot of wealth when it comes to his African customary law casebook, as well as 2 volumes of the restatement of African customary law, one in marriage, the other one in divorce. Well, he presented the document and the findings to the Legislative Assembly by that time, but his report was met with some conflictual controversies from the legislators. The question was the divide and rule system of the British that had divided the Africans themselves and kept the Africans away from the colonial regime. By that time, well, not so much had already been discussed and put into deliberations, but all the same, the legislators ended up coming up with fragmentation of the acts dealing with marriage and divorce. Well, African Customary Law Marriage and Divorce Act, Hindu Marriage and Divorce Act, Christian Marriage and Divorce Act, as well as Islamic Marriage and Divorce Act. This again brings that kind of conflict in terms of different systems that were to be accommodated in under family law and the law of succession especially. Well, from this part, how do we rationalize about the development of African customary law as a system? Because the only system here in AFTA referred to as English common law, but also with subsystem of Cadiz Court within the constitution, uh, did not have a lot of offer to the African customary law. Well, Justice Cochran had to go back to Britain, where he was called to the bar by Lincoln's Inn, and he practiced, and he remains one of the brilliant legal minds or jurists under English common law, and the only one among many others that concentrated his focus on developing African law. Well, he died back in 2014, but his legacy has left a lot of wealth in Kenya. Only that, unfortunately, not so much has been expanded on what he did, no continuation of his project, and it seems that his departure was also the departure of the dream of African legal system that would really redefine the Kenyan legal system. Well, having this in mind, it reminds me again of one revered law scholar, H.W.O. Okoth Ogendo. This was a guru when it comes to land law, the question of jurisprudence and other areas of law, and he's referred to by his pupils as the guru. Well, a product of the Faculty of Law at the University of Dar es Salaam, the one who did so much work, and one of his prominent contributions is about his thought about the Constitution without constitutionalism. Well, the distinction between the letter and spirit of the law in the Republic of Kenya had already been foreseen by this skillful and insightful law scholar at that time. Another person that I want to acknowledge is Professor Yash Pal. Well, this is a personality and a law scholar who taught law at the University of Dar es Salaam, where he also became one of the deans at the Faculty of Law before relocating to Kenya. In Kenya, he was appointed to chair the Constitutional Review Commission that brought the new constitution into life in 2010. Well, such personalities that are few indeed brought a lot of understanding when it comes to the history of law and the development of jurisprudence in the Republic of Kenya. Kenya, after the independence, committed herself in developing strong legal institutions, also dealing with the judicial system, which is still upholding till today. Well, other institutions like the Law Reform Commission in 1982, then again in 2013, as well as Law Reporting Council and the Legal Education Council, and so much is being done also at the level of the skilled and trained advocates under the Law Society of Kenya and Kenya School of Law, plus the universities offering law as a course and training. Well, all this brings us again back to our original position. What is the modus operandi when it comes to the legal system in Kenya? Well, the legal system in Kenya is English common law system with a subsystem of Cadiz Court with a limited jurisdiction, and only affecting those who profess Islamic faith and are also trained in the Islamic law and Sharia law. Well, how about African customary law? African customary law still remains in limbo even within the new constitution of 2010, in which not so much has been captured and articulated concerning the existence of African customary law, apart from the fact that Kenyans are proud of their cultures and heritages, the diversities, traditions. Well, all the same, the Bill of Rights allows also the access to justice as well as alternative dispute resolution mechanisms, including traditional dispute resolution mechanisms. This might revive the desire to rework the dream of Judge or Justice Eugene Cochran, and as per now, there is dichotomy of law. Well, dichotomy of law as a concept gives that reality in which an individual lives in respect with African customary law and traditions, as well as obedience and compliance with the enforced state formal legal system, the Constitution, and the Acts of Parliament. This brings us to the dichotomy of law which operate at the same time. Well, this is a reality among the pastoralists in Kenya and as well as among some members of people living in the coastal region, as well as the rest of all Kenyans. Thank you for watching. Peter here. Remember the rule of thumb, subscribe, and again, ask for notifications for some of our new debates and discussions. Thank you for watching, and I expect to see you again later. Thank you very much.